Abusia mo bibi akwaba na me family and platform we so ena ye da ye wurada di lumba the legend Charles Kojofusu omu ekwakuja na kwan ye man kwan so jojo abusiafo nyina ye momo yakọ wati ase ya rehosem papa abusia enye den ye de bebra mo Awal Mohammed NPP communicator na odi nsem bia ba montin so efa pandai ye rerano na madika aka chem se Awal Mohammed we the way we see can in the way we see a presenting in some social media no sometimes aya na a style bia wodwen ho awonti ase ubisa ho se nti sa kwa we osua de sa kwa we enti no sabi NDC fo nyemo mu yi sabi otikrom a ebiafa na adwen mu anyway we share ni meter ewo eye platform no so na odi ni tro no wie no na ni meter NDC communicator no so eto no boase schooling ni kama because se wudi ntra ayana anytime bia ye obi a uti enye ye obete oto especially in politics. MPP for they are what they are known to do, they are known for that. Say they be the ban tro or mo the ban tro sem yen kama yen no currency propaganda omuni papa yenti ofan edi kan na ye koba ye beto aso joy prime ena omudi say juma di we share so amen so monye bia me di ba so mo yenti bi.
Thank you so much and good morning to our cherished viewers and the audience in studio. When you check the charge sheet that they presented before court, they were seeking the annulment of 41 polling stations. And they said there were anomalies in the 41 polling stations. And that is the basis on which I said that indeed they were not going to seek the annulment of the entire resource because they didn't go to court to challenge the entire resource. They did not find anything wrong with over 100 polling stations at that time because that collation was done. That is one. Two is that, you see, in our electoral processes, after the elections are done, in the evening, if every polling station is counted, if you win the elections, you know. And if you lose, you also know. And that is right. Because, you see, at the polling station, after declaration, you're given a copy of the pink sheet that you send to your party office. So the lawyer saying that, well, the primary documents were destroyed. Yes, the NDC went on rampage and destroyed the primary documents.
I'm saying to you, but...
Okay. Why won't you allow me at least land? You've asked me a question. So I'm saying that they went on rampage and destroyed the materials at the EC office. But the materials with the NDC and NPP is still intact. If you ask him today, how many votes did Wakpal, what's the name? Did he use to win the elections? He can't mention it. They don't even know. This is more political.
Is that not the reason why there should be a rerun?
No, I'm saying that this is more political than law because you see, if there is any contention, I'm saying that Yindam won with 3,700 votes. If you think you had won the elections, you also tell us the votes difference that you used to win. That's very important.
Oh, wow.
But you're not telling us the vote difference. Now you are telling us that, well, there were problems with 41 polling stations. And you think the 41 polling stations had affected the entire resource.
Yes, so it's part of the argument.
It is true that it can affect the entire resource. It can affect the 41, can affect the entire resource. But we have precedents in this country where when you go challenging polling stations, it is granted. The polling stations are granted and the rest are protected. It happened in Akwatia. 6 polling stations could have changed the resource. And they went to court. They won. And Baba Jamal, on the basis of that, became an MP in 2012. So there were precedents in this country where when you go seeking for annulment of a polling station, it is granted. Even the recent one at Ablekuma North. We ran only 19 polling stations. So the reason we're saying that the court did not really give a judgment that we think upholds the rule of law is that the person came to court seeking for annulment of 41 or seeking some problems with the 41 polling stations. Why not protect the rest? Tell them to go and rerun the 41.
Okay,
if today he has said that we should go and run the 41.
Let me ask you a hypothetical question. If you're counting a set of 10 and you get to 6, and in that 6 you find that probably it's been inflated,
the rest of
the numbers are not necessarily reflective of what the total number of voters are in constituency 6. Are you sure that you get a true outcome of the elections?
No, you didn't give the right scenario. It is not 6 out of 10. 152, 41 out of 152. So over 100 is intact, and they did not find any problem with over 100. They had problems with 41, and they think the 41 will be able to really change the results, and that is
How will you do an effective tabulation if you don't have 44 intact?
No, I'm saying that is the reason I'm saying that.
Yeah.
The 41 could have changed it, because 41 polling stations has over 4,000 votes there. So definitely it could have changed it.
Yes.
So if the court, we were expecting that even if it had won in court, it should be a rerun of 41.
Okay, but
And
on
not
face
really-
value, it wouldn't have been the true picture or outcome of the elections.
I don't understand the question.
Well, you know what I'm saying?
Yes, I don't understand the question.
I'm saying
Yes.
that at that moment, we can all conclude then that
Yes.
it wasn't a true outcome of the entire elections.
So you see, we challenged it and said that both parties have all the original.
No, that's not my
pink
question
sheets.
to you, Awal.
Coming.
My question to you is, at that moment then,
Yes.
you don't have the true outcome of the entire elections, do you?
We have the true outcome together with the EC, because the EC gazetted, I'll come with on the Gazette. EC gazetted that he won with 3,700 votes.
Yes.
So that's a true
But I'm saying that you agree that the 44 might be problematic.
So if
at
the
that
41
particular
becomes
moment,
problem,
you agree, Awal,
yes, I
but
agree.
you don't have the entire outcome,
I agree that
the true picture of
41,
the
the
election.
41 polling stations, you see,
Yeah.
all our polling stations, initially it was around 1,000 and so on. It was broke down to like 500. All police stations don't go beyond 500.
I get that.
Some are 600 and so on. So if you put the 41 polling stations together, granted it's even 500,
Yes.
you get over 4,000.
But I'm saying
You
to you
understand?
that you get a distorted outcome of
That
the
is true.
entire.
That is true. That's what I'm
so
saying.
if you agree, is that not what the judge is saying?
No, that's what I'm saying. That he could have told us to go and run the 41.
When indeed
As
there's
it
a
was done.
relief, when indeed there's a relief saying it affected the entire results.
Well, I don't know which part of the charge sheet, because I have the charge sheet here. I'll go through and check.
Okay.
Yes, I have the charge
Because
sheet.
you had the same.
No, I'm saying that I have the charge sheet here.
Yeah.
I have the charge sheet here. I'll go through and see where they said the entire results should be nullified. I have not seen that in the charge sheet.
Relief.
To be very honest.
Relief.
Okay.
I mean,
so
he's
I'll
here,
check.
he could just-
So
he could just-
that is one. Two
yes.
is that
Just land so he
on
could-
the
or
Gazette,
let's
on the
take copy on
Gazette,
that.
it's wrong, because the Gazette, it has even been determined by the Supreme Court in the Akwatia case on the 11th of June. When they went to court and we challenged that indeed the Gazette was done on the 24th. That was what we presented to Supreme Court. And they said it was done on the 6th. That is in the case of Akwatia. Then we went to the Supreme Court, and the judgment that came from the Supreme
Yes.
Court says that it is the 24th. That is the original Gazette date and not the 6th. So that's the reason we are in the Supreme Court.
You're talking about two different things here.
I'm not talking about two different things. He understands what I'm talking about. Because as I stood here, I heard him talk about
Yes.
the Gazette that was done on the 6th.
Which one was Martin Yinam relying on?
You see, it is not about Martin Yundai relying on anything.
No,
it is about the law. What is the law saying today? That's very important. You may commit a mistake whilst processing your case. That's the reason. Even prosecution, they enter something, they tell you that they are withdrawing to relay it again. So there's nothing wrong with whether Yindam presented the cease or so. There is a Supreme Court ruling which is a law.
From the perspective of your party, which one was the actual date of the Gazette?
So the actual date of the Gazette, not perspective of a political party.
Yes,
I'm reading from the Supreme Court. I'm reading from the Supreme Court.
Yes.
On the Supreme Court ruling in Akwatia on the 6th of on the 11th of June. It says that just at the tail end of the, that is page 7 of 21 of the
You're
ruling.
talking about two different cases.
I'm not talking about when I land you understand
Yes.
it. When I land you understand.
No,
from the affidavit, I'm coming. From the affidavit of record, it was established that the Gazette notification of number dated 24 December 2024 was the valid one. We therefore have no difficulty finding that the results of Akwatia by-elections were gazetted on the 24th of December. Now, when you come to Akwatia, Yindam,
yes,
that is so Pandai.
Yes.
This is the Gazette, and the Gazette is saying that Yindam was gazetted on 24th, and this is on page 8123 of the Gazette document. So this Gazette is the right Gazette that was sent. So that is the reason we are
sent to who?
That was when you go to the publishing house. That is what has been published.
Wow, but Ninam himself is telling you that he's working with the same general document.
Then why did we go to Supreme Court that on the 16th that this one will be adjudicated? You are rather confused. I'm saying that.
No, Awal.
No, you are rather confused.
Are you saying that in your new case?
Maybe if you stop asking me the questions, he will also give you clarity.
Okay, then.
But I'm saying, let me end.
If you agree that,
let me end.
No, so that I'll give you the time again.
Why wouldn't you allow me?
I will allow you, but let him.
No, let me
end
and tell you that indeed we have filed an appeal.
Yes.
Challenging the results, the outcome of the court in Tamale. We're challenging that. However, the legal team of the party is in Supreme Court saying that even the entire process that happened in Tamale High Court should be declared null and void because of the 24th Gazette.
And you're working with 24th. And I'm saying that before the judge was working with 6.
So I'm saying that the entire process, whether he worked with 6 or 24 for anything, we're saying that the entire process lacks jurisdiction because between the 24th and the 25th that they filed their case, it was beyond the 21 mandatory days of the CI to 27 that we used to run the elections with.
Again.
That's very important.
Council, which states were you working?
I mean, before I come to that, I find that a lot of people have difficulties with the matter in question. So this is what the petitioner did, and let me avert your mind to. So Section 6 of the Representation of the People's Act, it says that the validity of an election to Parliament may be questioned only by a petition under Section 17 to 26. Now it goes on to tell us the relief which may be granted, Section 19. After the hearing of an election petition, the High Court may make any of the following orders. A, declare that the election to which the petition relates is void. B, declare that a candidate other than the member whose election is questioned was duly elected. Or C, dismiss the petition and declare that the member whose election is questioned is duly elected. Now, 20 talks about grounds for cancelling election results. Now let's take 21B. Now that there has been a non-compliance with a provision of this act or of the regulation, and that it appears that the election was not conducted in accordance with the principles laid down by law, and that the non-compliance affected the results of the election. Now, just a couple of minutes ago, I have stated that the gravamen of our case is to the non-compliance of the regulations as stipulated in CI 127. I've gone ahead to say that the irregularities and inconsistencies on Form 8A, the pink sheets, for 41 police stations, is to show the prevalence, the extent of the prevalence of the non-compliance in one particular instance. However, Regulation 43 talks about collation. You have to designate a collation center and all that. Now, we are saying that the electoral officer did not have the powers, acted outside his powers when he moved the collation center from the original center to the other place without recourse to our candidate.
So non-compliance was the basis.
It's basically non-compliance with provisions.
But is there no provision for a surgical redress, if I could call it a more targeted approach?
That is for the court to do, and I've read the reliefs to you. What you need to do is to put your evidence before the court, and we did that. And we showed that, you see, he alleges that the NDC's candidate and the NDC brought tax and destroyed. So the EC made similar allegations and produced video footages. About 8 of them, all 8 video footages were played in court. In nowhere was the NDC candidate or the NDC, supporters seen in that video destroying materials. Now we put it to him, if he could identify Honorable Nsala Wakpa or any of his supporters in that video, he could not substantiate it. It's about evidence. So when you make allegations in court, it will be scrutinized and subjected to strict proof. If you are not able to prove your allegation, what happens to it? It means that the probative value that the court will place on your evidence will be small.
Yeah, but the question about remedy as to whether or not the judge could have done a more targeted ruling, is that not provided for in this?
So like I said, if you are talking about just 41, you may be misled to go along that time. But that was not the only issue before the court. Like I said, so our client's right of participation was curtailed. He was not allowed to be at the coalition center because he was not communicated to. When the distractions occurred, coalition suspended, and when normalcy resumed, he was not communicated.
There's no official communication
to
from
him.
The Electoral Commission telling.
So neither the candidate nor his representative or any of his counting agents. What it effectively means is that he has been disabled from participation, exercises the right of participation, exercises the right of challenge of any anomaly or irregularity that he feels or is seen to have affected the elections. That is also another material issue that was put before the court. And so it's not just about counting votes. And like I said earlier on, I told you that the right to voting is paramount. It's a constitutional right. The people of Pandai deserve to have representation. I've also told you that procedure is equally as important. So if the procedure for which you arrive at the result is tainted, it affects the result. And I think it's a more...
Deal with the issue of appeal for me. He's now talking about two different, what's the name? The Gazette dates. Yeah.
So they filed an appeal, notice of appeal, and went ahead to file a stay of execution before the High Court. They've also filed a certiorari at the Supreme Court. Those matters have not been determined. Now, so far as those matters have not been determined, the order of the court remains. Now, if the court's judgment were that the elections were not conducted in accordance with laid down procedure, but did not go further to give further orders or organize a rerun in 30 days, it will just remain. It will just be a bare declaration that it was not conducted in accordance with the provisions, and then now it behoves on the Electoral Commission to now determine when it sees fit to organize a rerun. But the court went beyond that to give a time frame, 30 days. You understand? Now, you just don't say that, oh, well, I mean, we filed processes in court, so why don't you just wait for those processes to be exhausted?
You feel that must be respected first.
The point is, the lawyers of Matthew Nyenda, Honorable Matthew Nyenda, know that in order to set aside the decision of the court or vary it, you must have your day in court. And that is why they filed an application for stay of execution. The mere filing of an application of a stay of execution before a court does not operate as a stay. So, and I believe you all know, I think they appeared in court on the 10th, and the court will give its ruling on the 18th of December. I mean, they could just have stayed at home and relied on the appeal. But because they knew, and they know, that the orders of the court ought to be complied with, they had to bring an application for stay of execution. So it is one thing having processes in court, and another thing sitting somewhere and preferring an opinion. And I respect the opinion of everybody. Okay. But I'm saying that before the orders of the court will be curtailed or suspended,
you must first of all respect what
you must file the application, go to court, and argue that there are exceptional circumstances for which the court ought to stay its judgment for the appeal to be heard.
Okay, I'll come to the studio audience shortly.
Let me hear from Dr. Bawumia said, why the indecent haste by the speaker to declare the seat vacant when there are precedents in this
until there's a change in the ruling.
Because you see, the speaker cannot even declare any seat vacant.
Really?
Yes, he can do that. It is Article 99(1) of the Constitution that says that it is the High Court that is that can declare any seat vacant. But on the charge sheet, I'm coming. He said on the I. You said I, right?
It's a petition.
On the petition, you said I, right? I have it here that in an order of the second and third responded to conduct a rerun of parliamentary elections in the affected 41 polling stations out of 152 polling stations in Pandai constituency on a date determined by the court.
Which petition do you have?
The one that you have.
What's the date? What's the date of that petition? When was it filed?
23rd, 12,
So
2020.
that is not the petition we are talking about.
So which petition again?
So, like I told you,
Yes.
like I told you, the petition for which judgment was given was filed on the 25th
So this one,
of
you
January.
withdrew this one?
We discontinued the earlier petition.
No,
I don't understand.
This one was not before court. So what you're reading something else.
This is something that was certified by the
but it
court.
says you're reading a straight document.
So that's what I'm saying, that you withdrew this one.
So let me explain to you.
Yeah, but okay, but if it's not before court, why then? would
So
you want to-
let me
would you want
explain.
to
This
This is
rely on?
what I have.
Okay.
And I think
what you
and
have-
it's
You know what,
signed by the court. That's
Councillor,
why
I'll come
you
back
even
to you.
asked.
Councillor, let me hear from Noah. The whole issue about the timeline, what the provision of the law is. I don't know if you have a take on that. And also, there's the belief that, look, don't rush this because there's another process going on in court. What's your legal perspective on that? The fact that at least there's a standing ruling. Some people say, wait, let's see what happens. Some say you have to respect the initial orders. What do you stand in all of this?
Yeah, so I think I would start by first clarifying something that I think has been lost in the way this issue has been communicated. And I am reading the judgments of the court. And so the parties presented their issues before the court. And when I read the petitioner's issues, I see 3 of them here. I don't think any of them was really about just the 41
Exactly.
polling stations.
Exactly.
The idea is that the petitioner is saying by reason, in some of the issues, by reason of what's happened with the 41, then it may taint the entire election, right? So when a petitioner is asking for that, it requires the court to go beyond the 41 polling stations. It requires the court to delve into the circumstance affecting all the other results in the various polling stations. So in elections, we said there is a difference when the petitioner is seeking a qualitative issue to be determined and when there is a quantitative issue.
Exactly.
So the quantitative is when we are just putting the results together and say that, well, if we put together and we tally, what is the
You do
figure?
like a 1+2.
Exactly.
Get this.
So in those instances, like he is saying, I think the court could have just said, well, the difference around 3,000. You are just only challenging the 41. Even the 41, when we put together all for you, the petitioner, it won't reach the 3,000.
I'll come to you.
And so by reason of that,
If you go beyond 3,000, if you put 41, it will go beyond.
yeah, so in those times, the court could have just said that, then let's just go and conduct for the 41,
41, yes.
right? Or even maybe we don't even conduct at all if it wouldn't change.
Okay.
But when the petitioner is challenging the quality of the election, it goes beyond mere counting the votes. It goes beyond, like he mentioned, for instance, whether the person was allowed to participate in the election process, the counting, all of that. And I think if you read the court's judgment, that's what the court had in mind, that because of the alleged irregularities that tainted the elections, it will be impossible to come to a conclusion that those results that we even have for the other polling stations were not affected, possibly in the accounting by the same issue. So I think that's what played in the mind of the
Coalition
court.
would then come into the picture, which
Exactly.
is the entire spectrum of the.
Exactly. And then I'll comment maybe briefly also on the issue you brought up concerning whether there is a haste to conduct the election. And I think we have to look at the constitutional provision on Article 99 carefully. I have always maintained the view that Article 99 gives the High Court the jurisdiction to do 2 important things. One of them is to address issues about vacancy in Parliament. And the other is to challenge, when there's a challenge, an issue concerning the validity of an election. A lot of times lawyers have commented on this issue and have treated the two as the same, but that is not what the draft of the Constitution had in mind. So 99 gives 2 different jurisdictions to the High Court when it comes to matters affecting whether a person is properly an MP in Parliament, right? One of them, which is on the vacancy, is, in my view, what Article 112 addresses. Those may be issues like death occurring when the MP is in Parliament, the MP resigns, or the MP is removed for some misconduct.
Then it will become big.
For that, it is Parliament that must communicate to the Electoral Commissioner that because of this person's seat has been declared vacant, and so conduct an election. Those circumstances, the EC is not in Parliament, so that is why the EC must be informed administratively by the clerk. But the person whose seat has been declared vacant in Parliament may challenge that decision by the Speaker, for instance. And the High Court,
at that point, it would have been a parliamentary process.
exactly. The High Court can look into that matter and come to the conclusion that Parliament followed the right processes in declaring the seat vacant. That is different from when there is an election petition that goes before the High Court, for the High Court to determine whether the election was validly conducted. In those circumstances, that does not emanate from parliamentary processes, right? And that is why the EC is a party to the suit. So in those circumstances, it does not even fall on Parliament to declare the seat vacant. Immediately the High Court ends the case and declares that that election was not valid, that seat is automatically vacant. So I am even surprised that Parliament is
so
even...
So a call by the MP saying the Speaker ought to recognize Nyinam for a while until the determination. It doesn't even...
It doesn't even arise at all. And I give an example which I think will help us. If the EC declares a presidential election as invalid, at the time the court would have done that, the person would have been sworn in as president, because by January 7th, the person will be president. So let's say somewhere in February, the Supreme Court declared the president's election as void, invalid. The person cannot continue to be a president. There is nothing like a stay of 7 days to allow the person to respond, nothing like that. From that day, the person ceases to be president, because the court has been given that jurisdiction under here, the High Court, on Article 99, to make that declaration. When the court makes that determination that the person's election is void, the person cannot be accommodated.
But how about President? Because some of the parties are pointing to that. That look, it's happened in the past for some other people. What's different now?
No, so I speaking about the Constitution, I am of the view that that is not the right process, right? And the fact that it has been done in the past, which I believe is wrong, does not mean it should continue. The proper procedure is laid down in the Constitution. So far as the High Court come to that conclusion, the person cannot be accepted in Parliament. Because who will he be representing? The basis of his presence in Parliament is the election. And that election has been challenged.
So the clerk cannot be faulted for...
No.
For saying...
Properly speaking, like I'm saying, the clerk should not even come in. But the EC is the party to the suit. I'm sure the EC...
They ought to respect it and
exactly. That's why the court directed that 30-day to the EC.
We were thinking that there will be an execution first, even if the court had really declared that indeed they should go and write. So we were thinking that there will be an execution of that.
Execution of what exactly?
There should be maybe the court coming to really notify Parliament that indeed we have declared.
But the judgment has been made by a court. We all have to respect that, isn't it?
We respect the judgment, as he said. We respected the judgment is the reason we had to go on appeal.
Yeah, but our Parliament has
seek for stay of execution, and again have another case in Supreme Court. What we're saying is that because there are precedents in this country where after the court had made declarations of seats and the processes,
well, you just said him
the processes of appeal had started, you don't hear any speaker declaring any seat vacant until the processes are done. We were thinking that let's exhaust all the legal processes.
Is that not giving a human face to it?
No.
As of the point of law.
Precedence is very also important because in the case of Jechi, there were no pending cases in court before the run of the elections. There was no single pending case in court because he lost all the cases in court. So we're hoping that at least let's finish with the legal process. Why the haste in declaring the seat vacant? That is the reason we're saying that it's more political than legal.
Okay, I'll come back to you, but let me go into the audience. Let's get your take on what's happening here.
All right, Blessed, thank you very much for always giving us the opportunity to speak. And I must say that we live in a democratic state, and the beauty of our democracy is that we have a constitution which we must abide by. I think the points the NPP is making in this very case lack legal standing, and so they resort to more of emotional blackmails, and it's even clear from the submission. He said that it lacks legal standing. It is more political than legal, but this is a case of legality. And let me remind Awal of something, that the Constitution is emphatical about this thing. When you check the Court of Appeal amendment as amended 2022 CI 132, it states categorically that a ruling by a court remains binding unless it is set aside by a higher court. The lawyers are here, they can correct me. And so when the court internally gave their ruling, and the clerk also performs his constitutional mandate by informing the Electoral Commissioner about a vacancy, if what the NPP is expecting is that a stay of execution should be granted, but a stay of an appeal in itself does not automatically imply a stay of execution. And if you are saying that you've won by a huge gap, and you are very confident that you have won over 100 and there is no problem with over 100, then what prevents you from going into the election? I believe that it is more democratic of them to go into the election if they believe that truthfully they acquired the legal means to win the previous time. They can still go, because this time around the conditions and factors for which they won the previous time, I believe the constants are still there.
So you're telling Awal that if you're not scared, just go back in.
Just go back. I encourage them, because the beauty of our democracy is such that it has to be inclusive and participatory. So they must participate. The grounds are there. The people are waiting. The Pandai people are waiting. If they truthfully want you to serve them, they will still give you their mandate. But I think Awal is scared because they have realized that they have missed the ball. So the only thing they are implying to now is not to miss the man. And that is why you could see clearly that the minority in parliament, went to parliament the last time strictly to interfere into government business, to make sure that the business of the government doesn't come to play. Just because they do not have a point. They do not have a point. So my point is made and done, and it is straightforward that they should go into the election instead of delaying the processes. And I don't think that they have any legal, if they have any legal approach to
at the last check, I'm not sure that the voters register for the Kwandai constituency has been revised. So it will still be the same set of electorates, isn't it?
But general elections are different from just by-elections. By-elections don't report even up to 40% turnout.
I see.
That should tell you that someone in Accra may not.
But no one is prohibited from voting.
No, you see, the thing is that in a general elections, people check their calendar, they do everything, then they can go and vote in a general elections. That is the reason. I'm coming. That's the reason a lot of people are saying that let's declare the day of elections a holiday so that people can go.
Yeah, but if you're confident that you would win, why don't you?
I'll address that. I'll address that.
Let me hear you.
I'm reading from 3 News.
Yes.
Dated April 16, 2022. There can't be a by-election in Asindov until final determination of the case. This from the NDC lawyer. In the case of Asindov,
which of the cases are you referring to?
Yeah,
he's talking about
from 3 News.
I get that. Yeah. I'm just asking in respect of what?
Asindov.
This is not Pandai.
No, yes. So I'm coming. I'm the president.
President.
Very important. With the case of Asindov, the final decision came from court.
Yeah.
I don't think he was there, or there was a president in parliament that didn't do. The court, his case was in court, and then the court declared his seat vacant. The same way, they said they cannot be a by-election until the final determination of the court. And then we waited for them for everything.
All right. That's
No, this is Ibrahim Amaliba. The legal director of the NDC.
Yeah, but what authority
and now the same thing is happening now. And now the same thing is happening now. And we're also waiting. We also see, let's wait for the determination of the court.
Yeah, but the final determination. There's an argument by a court, isn't it?
So now, I'm saying the lawyer for
the lawyer.
For Honorable Nawal is here, Honorable Insala is here. Council, please, I want to ask your candidate, during the coalition, where were his agents in the coalition? And after the coalition, or after the chaos in the coalition center, did his agent call him that this has happened? And then the EC...
he told you there was no official communication.
No.
I'll give that.
But he will have to understand this.
Since he's here,
I get that.
Yeah, okay. I want to know, your agents in the coalition room,
yes,
did they inform the candidate that the police are moving the EC to a different place, which we don't know? And I know the police is stakeholder in the election. And the candidate even called the police commander in Pandai district that this is what's happening. And what's happening. And we want to know all of this. And also, you are having police agents in all the police stations.
Okay.
And I'm sure they brought you the pin sheets for you to do your private coalition.
So you're saying that even if you take the EC out,
I think they have their own pin sheets that they collected their results. So they should be able to tell us the result they had. After everything, what they had.
Okay, I get the point.
So for that, we don't know. The police, the candidate, was it deliberate thing?
Yeah.
He knew he was losing, so I have to wait. When white people wins, then I come and challenge in court.
Okay.
Because
I'll
from
put
the way
that
things are going, it's like it sounds deliberate.
Okay.
Like intentionally they are that because you have an agent there. Your agent didn't tell you that they are moving here.
I get
you didn't
that.
call the police commander. You didn't do anything, and
Okay.
they are here challenging it in court.
Yeah.
It's unfair.
I get that. Just calm down. Don't worry. The lawyer is here. He would answer. Okay. Kamal, I'll come to you after him. Yes. Yeah. Yeah, we're having challenge hearing you. Probably you can switch the microphone. Yes, okay, now we can hear you. Yeah. Kamal, you can hand yours over to him. Maybe he would, briefly. And then,
We heard the organizer of the New Patriotic Party, Henry Nanabuachi,
yes.
said that Ghanaians have regretted voting for the NDC. And if elections were held today, and I have heard Awal said several times, I follow Awal,
Yeah.
and he has said several times, I think this is a clear case study. The Kwanda election is a clear case study. If you think that Ghanaians have really regretted upon all what we were put into, the economic quagmire, the turmoil we were plunged into as a people, the misery we went into, and we got a savior to save us upon everything. If you think that the Ghanaian people have really regretted, this is a clear case study. Allow us to go into the election. You see, Bless, what is happening is that if I were the New Patriotic Party, and Awal said something, he said that the lawyers of the petitioner went to court to seek some reliefs, and the reliefs included the annulment of the 41 polling stations that were affected. But Awal knows that in the wisdom of the court, you can go to court and seek relief A, B, C. The lawyers are here. But for precedent's sake, the court can add E, F, G, A to even Z to you for precedent's sake. If I'm lying, the lawyers are here. And so even if that is what they went to court to seek, for precedent's sake, and the judges have what we call a substantial effect when they are dealing with a case. What they do is that in the case of Ablekuma, that they keep referring, the substantial effect compared to Pandai, what is the substantial effect here? In the Ablekuma North election, it couldn't produce a member of parliament. Now, in the Pandai election, it was the irregularity where it was able to produce a member of parliament. So that is where the substantial effect lies. Now, you come to this.
So you're saying there can't be any two things?
No. One has been able to produce a member of parliament. The other was not able to produce a member of parliament. So if you are rerunning the 19 polling stations, that is fair, because the substantial effect is not as compared to the Pandai election, which has been able to produce a fraudulent member of parliament. A fraudulent member of parliament. But maybe this time we should see what is happening. If I were the New Patriots, especially the Nando minority, because they are now shifting from micro.
Okay, let's move.
If I were them, what I would have done is that we would have used the moral suasion instead of doing this buga way. Because the moral suasion, let me land. Moral suasion is the act of appealing to the principles of somebody to let them know that what you are doing is bad. Because the NDC is not doing anything illegal, and so they should know how inconsequential their numbers in parliament is, and stop this buga thing and another telling on the floor of parliament and telling somebody get away.
There are some questions. There's one question to counsel. Counsel, I think there was a question from the individual asking you. The point about communications from the agents to your candidate. Is it that there was no? Is it the case that there was no communication?
So you see, that is a very simplistic way of looking at it. No, before elections actually begin,
I'll come to you.
Before elections actually begin, the Electoral Commission designates. When we start from a rate of election, then there's the notice of election, notice of poll. You pick your nomination forms and all that. Now, there's a designated point where the exhibition, the register is exhibited. You understand? It is designated. You can't change it. It is designated right from that point to the particular polling stations, and it is backed by law. We all know from the start where the coalition will be had. So if there's a disruption during the coalition exercise, and it suspends the coalition. Now the rule says that where there's a disruption at the polling center, and there's a disruption, now the presiding officer there can suspend the elections at that point for a day, and then if after a day, normalcy is not restored. I mean, there's another period designated. But when it comes to the coalition center, the law does not expressly say that you can designate, change it on your own. We are saying that since the law provides that you can suspend it and come back to that same venue at a designated time, that is what should have happened there. So if you intend to change it, there must be a formal communication
and not just to you, but to everyone to say
exactly.
This is
but
where
this
is
when
validate
the results.
Hold on.
It doesn't. Even if you change, it doesn't, because when you check 2013, the Supreme Court ruling.
So you know,
but he's saying
so,
that then. Okay,
so like I said,
yeah,
we went to court stating and alleging a number of infractions with the provisions. You understand? And this is one of them. So we are saying that if you intend to change the coalition center, there's a procedure. You don't just do it so much and say that, well, anyway, for whatever reason, you had intelligence, you picked intel from the national security, and that is all well and good.
Give me one. I'll give you the chance. Let me just finish. I'll give you the opportunity.
You have to communicate to the parties involved. Now, when there's a disruption and we suspend proceedings here, because of the nature of the fight, we may probably scatter all about. If you resume recoalition, you have to call everybody in before you start, because I am entitled to be at that coalition center. Now, when I come here and the program has been moved to another venue, how am I supposed to know if you have not communicated to me? So what we are saying is that it's not about just common sense, it's about following the procedure. The Electoral Commission is bound by law to conduct elections according to a particular procedure and regulation. And so...
Hold on, let him land. He's answering your question, so let him land.
The question and the answers are...
but you can't force him to give you what you want. He's telling you what I'm
trying to tell him.
So let's listen to his response then. Just hold on. Okay, guys. Allow him to. Please let him answer. Yeah, it's fine. Okay, let him answer. I'll give you all the opportunity. Yeah, so let him answer. Yeah. So hold on. Let him answer. I'll come back to you. Yes. Okay, guys. Yeah, I'll come back to you. Yeah, I'll come back to you. It's okay. Yeah, it's okay. Just calm down. I'll come back to you. It's okay. Calm down. Yes.
So what I'm trying to say.
It's okay, guys. Yes. Let's listen. Yeah. Let's listen. I'll come back to you. Just hold on. Yes.
Let me use this analogy. What I'm trying to say is that.
Yeah.
So let's use the Ghana Premier League.
Yes.
We know when a particular team is playing another team and which venue right from the start.
Yes.
So let's say you are supposed to play Hearts of Oak.
Yes.
On the 20th of December at the Accra Sports Stadium. You produce yourself at the stadium.
Yes.
Hearts of Oak does not show up. The referees don't show up. And instead, they go to the Tema Stadium and say that you didn't come, you didn't produce, and so you lost 3 points. You understand?
Yeah.
You didn't show up at the venue, so you've lost 3 points. They expect that when we got there, we saw a snake at the entrance, so we moved to Tema Sports Stadium. We expect that you should know and come. That is not what happens. There must be formal communication that because of A, B, C, D, we have moved the venue. Okay. Because you see, and I've told you that by moving the venue, you have disabled him from exercising his right of participation and even his rights as far as even challenging the results, as far as even asking for a recount. All those possibilities can arise.
Okay, because we're pressed for time, let's be very snappy so we can talk about the OSP issue, because that's also another one on the agenda.
I think my colleague here made mention of Ablekumanov when he was citing an example. The mistake here is that for Ablekumanov, the court gave an express order for the Electoral Commission to go and declare the results when 3 were outstanding. So you should get it. The 19 rerun was not a court order. Yeah. It was an EC's order. So let's put that one aside. But Blessed, I'm surprised you are joining people to say, if you are confident of winning, why not go?
I'm not joining.
I'm surprised because no. You are not supposed to play such a devil's advocate.
Oh, really?
In that, if we want to go by that tangent, many parliamentarians will have to go for rerun again. Because I can decide today, or another person can. Please, when you spoke,
so allow him to land, and then I'll give you all the opportunity. Just come down. Yes.
Somebody can equally win an election by, say, a margin of 50,000, and another person can challenge the results, and you tell the person, if you are confident, just go. Where is this done? So we shouldn't let that.
But is it not a fair question to ask?
It isn't.
That if the court says
because
you didn't follow procedure.
Because if you want to be going by that, and there will be chaos. Many people will petition against it, and the only answer people or the suggestion people say, if you know you can, we just go for the rerun. Where is this done before? Now,
yeah, but I'm saying that it's not a fair question to ask.
It isn't to me.
Look, a court has made an order. You disagree. It's becoming a very prolonged exercise. You have a shorter route as maybe member of parliament who has legitimacy in the constituency. That look, when elections are held today, the same set of people will be the ones going into the elections. That's why I'm asking the question. Is it not fair to just
if you are dealt with unfairly, another person tells you that you can still go back because if you are sure that you win, why have qualms about the election? Yeah. That's what I'm saying, that let's put that aside because I totally disagree with you on that. You see, you asked counsel about the gazetted results, and he's beat about the bush. It's not straightforward. The official Gazette report was done on the 24th. This is a Ghana News Agency. EC Gazette's 274 parliamentary election results. 2 constituencies outstanding, which is...
Are you talking about the presidential or the parliamentary?
Both. The parliamentary. In fact, parliamentary. Here, it's parliamentary. Let me go over. EC Gazette's 274 parliamentary election results. 2 constituencies outstanding. The 2 constituencies were Dome Kwabena and Ablekumanov. So they were gazetted. We should just get it straight, regardless of whatever somebody took it. The official one.
Do you know why I'm asking you the question?
The official gazetted report here is that what was gazetted.
Yeah, but do you know why I'm asking that question? Well, because I'll give you the opportunity. But the reason why I'm asking you for clarity is that at the parliamentary level, the returning officer, I need some education on this, is different from the presidential, right? And so when the process is completed, I think I covered Dome Kwabena. After the exercise, you officially have them, they're supposed to paste at the center, and then later on, declare and all of that.
Submit to the region. He will submit to the region. The region will submit to the national. Then they will submit to Assembly Press for it to be gazetted.
Okay.
So that's what is done.
That's why I'm asking that.
The finality of your question, the answer I'm giving is that the official report here is that it was gazetted on 24th December. That's it.
So how come Martin Yendam was relying on that?
I said it's the official one. That's the remedy we are seeking for at the Supreme Court. So don't worry. Hold your horse. Now, you see, when it comes to declaring seat vacant, and then the determination must be done. In this case, we have cases in court, and we are saying that the Speaker should have held on to declaring the seat vacant, because if you look at what I have here, that is a graphic online, 31st October 2024. The Speaker of Parliament, Agban Sumana Kingsford Bagby, has failed to have the decision by the Supreme Court suspending his declaration of 4 seats in Parliament vacant reversed. Now, a part of the story, the import of the ruling by the Apex Court is that 4 members of Parliament whose seats were declared vacant by the Speaker, that is Cynthia Mamle Morrison, I don't want to go, will continue to be MPs pending final determination of a suit by the majority leader in Parliament. Pending. In this case, there are cases pending. So you just hold on, let the courts determine all these issues. And I was happy when I was stressed the point that by the time Honorable Jeji Kwesi's rerun was to take place, there were no pending court cases. And that is what should have sufficed that.
Should the Parliament of Ghana respect a court ruling?
But they can't disobey a court ruling.
They can't disobey. So if the court says that by December 30 or in 30 days, organize fresh elections, would you obey that first before doing an appeal?
But in this case, upon that, the disgruntled party person here has also gone to another higher court.
Would you respect the first order? Because you can't come to equity without
what?
Clean hands, right? If you have to first of all.
But in this case, it is the equity that has made him to go for an appeal. Is that not equity? He's not satisfied with the decision of a high court, and he's gone to the appellate court, and the party has also gone to the Supreme Court.
All right.
So let us. But you see, lastly, that's why you were interjecting me. I wasn't, because you talk of time. Lastly, let's look at what transpired in 2013. Some of the things council sat here and enumerated. Atuguba and Co told us that transpositional errors, the absence of a candidate to be there, not to be at the center, not signing, all those things do not invalidate
the results.
Those who have voted, you see, the 100 and something polling stations, now what they are suffering this consequence when their issue is not in contention.
All right, I get
now you are making them come back to come and vote again.
Okay, so here's what I'll do. Let me just take the final thoughts of you guys, and then we take a short break and deal with the OSP issue. I'll come back to you.
So you see,
briefly, Awal.
What my brother my brother here said is rational.
Yeah, I think let's listen to Awal. Let's listen to Awal, and then I'll get back to you guys. Yes.
Okay, so what my brother said here is rational. After the elections is conducted, after declaration at the polling station is done, they all move to the collation center with their with the ballot boxes with clips from the parties. The parties will have to put their clip on every ballot box. Then it is sent to the collation center. Sealed. You understand? It is sealed. Then it's sent to the collation center. If there are any disruption, we follow. Wherever the EC is sending it, the parties follow. So you are telling us, I'm coming. He said he's not really a political agent, right?
Yeah,
he's a lawyer. But I'm saying that. What happens at the polling station, at the collation center, when there are disruptions? In Senate West in 2024, there were disruptions like this. The parties followed everything to Techimai. And Baba Jamal, I'm coming. The legality is that there is no way you will leave that ballot box with the EC alone and police to send it somewhere. It doesn't happen anywhere.
But you have a place.
You were reporting at Gwami Kwamia, you said.
I did, yes.
Didn't you see the parties following in the pickup, holding the ballot boxes to wherever it is sent?
Yeah, but it came to one
and
center.
I'm telling you that
it was at the center.
It was at the center in Senate West in 2020.
Yes.
In 2020, in Senate West, there were disruptions like this. Some about 10 or 11 polling stations, just like this. Then they took it. The parties followed to Techimai. Baba Jamal, director legal at that time, went and added his clip to it until the court determined and it was opened and counted. So for you to tell us that after they changed the venue, you didn't even follow. You didn't.
Yeah, but he's saying that's not what the law says.
Okay. It is not true.
All right, okay.
It is not true that they didn't follow.
Okay, no.
That is one. Two is that when you tell us that,
because of
when we're told that, well, if you think you can win, why don't you go and run? I told you even last 2 weeks when I came here that this is a seat that belongs to the NDC from 92. We've never won the presidential before. But Yindam came in 2012 and won with a 2,000 margin. In 2016, he won again. In 2020, he lost and didn't really protest. Went back, sat and wept, and now he got the highest margin of 3,700. And yesterday, my general secretary, lawyer Justin Kodia Frimpong, also on Asempa, and he told you that we are following the court processes. We will do all the court processes.
So why are you picking and choosing the court processes?
If the court declares that indeed we should go and run, we will go and contest.
But the court, there's an existing court order asking you to.
I'm saying that we respect that existing court order. That is the reason we are on appeal and we are in the Supreme Court.
So until then,
if we are able to exhaust it, and this one will be exhausted by 18th.
Okay.
By 18th, I'm sure by 16th, because the first one is on the 16th, which is the Supreme Court. And I'm upbeat that with the date of Gazette and the date that they filed, it will even declare the entire process at Tamale High Court null and void. So the 18th will not be necessary.
No, I don't know if you have any take on the Gazette issue as well. The time.
Yeah. So I think what I have is basically a question and an answer, right? Gazettes publications can be changed by the same person who gazetted, right? So if the EC gazetted about 274 constituencies, my question is, at that time, were the 41 polling stations results added to it?
Yeah, it was added.
It was added. Right.
That was the reason they had to gazette.
But now, if it's been annulled,
so exactly. So at the time that the EC gazetted those 274, because I think I've heard the FM report say something to the effect that there were subsequent re-gazetting of some of the results.
So that is what they used. on the 6th.
So it is true that there were some
Yeah, but you see,
so you're making his point then, that it could be changed.
On Kwandai,
the Gazette could be changed.
The Gazette is on the 24th. That is what Kwandai's, that is what was done in Kwandai on the 24th of December. Not initially, the entire Gazette.
So there wasn't any re-Gazette.
There was a challenge. No, there was a challenge that there was a re-Gazette on the 6th, which they used to challenge the Akwatia seats. On the 11th of June this year, the Supreme Court ruled that the 24th Gazette is the right Gazette and not on the 6th. And they used on the 6th to challenge the process. That is the reason I'm saying that the case will terminate on the 16th because the Supreme Court will upheld it.
Okay,
so I think for me that's the question.
Okay, anyway, let's wait and see. Yeah, okay, counsel, just land for me, and then I come to we
so you see there are matters, there are legal matters, and there are opinions.
Yeah, right.
So let me just say that the orders of the court is for a rerun in 30 days. Right. Now let's take the Jachikwesin matter. Did the court order a rerun in 30 days? If the order of the court is that you are not eligible you were not eligible to have stood as a candidate in the elections, and then so therefore goes ahead to annul the results and says that there must be a rerun, there was no time frame.
No,
let me finish.
Let him land.
The Constitution.
Let me finish.
But let him land.
There is a time frame. The Constitution of Ghana is saying that if the court
can I finish?
I'm coming.
Can I finish what I'm saying? No, I don't need your help.
He's also.
I don't need your help.
So let him land.
I don't need your help. So I'm trying to. I'm trying to explain.
Ask whether there is a time frame in.
Allow him.
There is a time frame.
Okay, but allow him to.
In the order.
Yes.
If the, you don't need. Let me finish.
Allow him. Just allow him to land, and then we'll make progress. Yes. Yeah.
I'm saying that in this particular instance.
Yes.
A court of competent jurisdiction has added a time frame. Do it in 30. Do it in 30 days. You understand what I'm trying to say?
Yes.
Have the rerun in 30 days. So until that order is set aside, that remains the binding decision of a court. If you want to set it aside, you file process, and that's what the Honorable Martin Indian's legal team has done. They filed a stay of execution. Wonderful. They filed processes in the Supreme Court session. I have restrained myself from talking about the matters before.
Right.
Or that will come up before the Supreme Court, because I mean,
it won't be proper.
It won't be proper to go into details. Otherwise, we'll prejudice the matter before. But I'm just trying to say that if the legal team of Honorable Martin Indian are successful in staying the execution of the court,
then we abide by that.
Of course, because there are legal processes that ought to be followed for everything to be done. I can't just get up today and say that I've decided that the elections must go on. And so therefore, I go and railroad everybody to get the elections done. It must be done in accordance with the orders of the court. And that's what is being done.
Okay.
So if they're able to succeed in the stay of execution, all the better. I mean, if they are not successful, there are other processes that they can use.
Yeah, I get that.
So I think
okay.
So, but I'm saying in the case of the Jachikwesin, if there is a ruling from...
let's do the special prosecutor now.
If there is a ruling from a high court declaring a seat vacant, the Article 1125 of the Constitution is saying that it should be rerun within 30 days. In the case of death, it is 60 days. You understand? So the Jachikwesin one, you don't need any consequential orders from the court to tell you that do it within 30 days. The rule is that within 30 days, it should be done because the court has declared. That's the Constitution.
Okay. So you're agreeing with Noah. Okay. Anyway, let's not do this. Let's deal with the special prosecutor case now. Apologies, sir, because of time. Because we need to hear from Noah. Okay, because he's done something many have been asking and waiting for. Because but you've been waiting for this, isn't it?
No, I've seen Noah's thing, but I don't know where I'm talking to Noah here.
So I told him in the morning that a lot of people, I think you've been under the radar. I don't know if we should put it that way. Probably in the legal space, a lot of people will know you. But a lot of the politicians don't know that you are the one sitting here. So let's get to it then, so that we understand perfectly what you are trying to seek from the court. I want us to first of all but because of time, let's hear from you first, and then we proceed. Okay, but I'm told to just do this. Let's go to Parliament first and just watch the argument from both sides, including the majority leader on the creation of the Office of the Special Prosecutor. That's a special concern from...
Ewe enti sana nsem no ekwa akoba ye wacha se na anya no nko a omo wie sa issue ya na omo de the removal of a special prosecutor yewra Kisi Jabin so de eto ado na madi kan ka cho se Kisi Jabin de oyeye ya obekọ because ono na nkasa ka hwe na ohwe na opadwuma na jai dada but corruption ni nyima bi akoso wo hono minti no asanya akrepo no asanya akrepo na ontimi nyeden ontimi nko. But in the normal circumstance, no, you can attest to that fact. Say, a year Kisi Jabin obeko abusia for yanko na yenti sanse ni bi na yakoba yebetoa enunso eso enunso Awal Mohammed kuroye na opeso fa ho edidi tro sanse ono de we know him to be one of the most liars in this country. Ebano NPP communication a fraternity na otna social media ditro otna platforms ditro yenti no yakoba yebetoa so.
Okay, I'll hear from you shortly. So let's get to understand why you are in court and what exactly are you seeking from the courts.
Okay, so thank you very much. I think, like you mentioned, the rates I filed, which I honestly thought would just go under covers until the court hears, came into the public, and there are quite a number of strong sentiments about it. But I think, for me, it's a fundamental issue I've had since somewhere 2016. I've written extensively on it, on my blog, on my Facebook page, on why I disagree with the procedure that was adopted to set up the OSP. I am very careful with my language because a lot of people think I do not want an independent prosecutorial body, which is not really the case. My concern is with the procedure that was adopted in creating the Office of the Special Prosecutor. And I am a constitutional law lecturer and a student of the Constitution. So I believe strongly in the concept of the supremacy of the Constitution. Right. So when I read Article 88, my view is simply that Article 88, unlike the Office of the Special Prosecutor, Article 88 creates an Attorney General. It does not create even the Office of the Attorney General. And our Supreme Court has had the chance in a number of cases. Amidu, for instance, one of those important cases in which the Supreme Court has expressly stated that the Attorney General is the individual who is appointed.
Not the office.
Not the office. Now, beyond that, the Constitution also tells us that the Attorney General shall be a Minister of State. So the Attorney General is not just some individual that is away from the executive arm. He is a member of the executive as a minister. Now, we know in this country that, according to our Constitution, the executive is the president, right? Unlike Parliament, which is the members of Parliament, or the judiciary, which is the entire judiciary. The executive is the president, it's one individual. So the president appoints ministers who act on his behalf. So prosecution in this country is a purely executive function, right? And it has been given to the Minister of State, who is the Attorney General. So the Constitution under 88(3) tells us that it is this Attorney General who has the exclusive mandate to prosecute all crimes in the country. However, I'm sure the drafters of the Constitution knew how burdensome that task is going to be. So they expressly stated that the Attorney General may authorize someone by any law to prosecute. Now, that provision allows the Attorney General and not any other person to appoint some other person to prosecute.
Yeah.
Right? So if the AG believes that, I think I need someone else to help me prosecute an offense or some particular crime, the AG can appoint that person through a law to prosecute that offense. So it is in this framework, this understanding, that I believe the OSP's creation is problematic. Because when you read the OSP Act...
So all these provisions we can find in 88?
Yes, 88.
88, right.
Exactly. So the OSP Act commences on the assumption that... So we have to first start that it's Parliament that is passing the law. Right. It is very...
Subsidiary to legislation then? Or
not necessarily subsidiary. It's a full legislation, full statute. However, I'm saying that because the Constitution says that it is the Attorney General that may authorize someone. Right. Not Parliament. Right. So the question will be then, how would the AG authorize the person. There are a number of ways the AG could do that. Under our constitution, the AG can pass a constitutional instrument. And our Supreme Court has said a number of times that if you're not a judicial officer and you have the power to exercise discretion, you can do so through a constitutional instrument or even a legislative instrument. So the AG could have done that to appoint whoever he wants to appoint. But even if the AG wants to go through Parliament, the nature by which Parliament will pass the act must clearly indicate that the office we are creating is not independent of the Attorney General. Because the Attorney General is the sole person who has the mandate. If that office is going to prosecute, it is basically going to prosecute on behalf of the Attorney General. Because the nature in which the person will be appointed will establish a principal-agent relationship between the Attorney General and that person.
So you must have been acting on the orders of the...
Exactly.
That's 88.4 then.
Exactly, 88.4.
This is it. All offences prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law.
Exactly.
Is that not sufficiently catered for in the OSP Act?
So the drafters were very skillful. They tried to avoid it, but I don't think they did that within the context of the Constitution. So for instance, they say that the OSP is authorized by the Attorney General to prosecute, right? Which is what they tried to. And then when they talk about the independence of the AG, for instance, they say subject to Article 88. But that is problematic in one sense. And we have heard the OSP himself and then his officers always say that they are independent of the Attorney General. And that is they telling you clearly, and they understand of almost everybody, because the office we are creating, we said that there must be an office that is prosecuting specific offenses because the previous AGs were not prosecuting those offenses. So if there has to be an OSP, it must be independent of the Attorney General. That is what was the intention of those who drafted the act, and the OSP himself usually says that. So clearly they tell you that they are not in any way attached to the Attorney General. They are doing their thing on their own. The AG has no oversight over them, and that is where the problem is. But even beyond that, I try to raise a more interesting question.
Okay.
And that is that the AG being a Minister of State means he's appointed as a minister by the president. And until the AG is removed, he resigns, he serves at the pleasure of the president for 4 years. For the president, either until he's reshuffled, when the president loses power, that AG will also lose power. So the question is, the appointment of someone else to prosecute on behalf of the AG, can it bind successive Attorney Generals? So let's even assume that Godfrey Dami believed that there should have been an Office of the Special Prosecutor. Must the current Attorney General be bound by that discretion of Godfrey Dami that he wants someone to prosecute those kind of offenses for him? In the next 4 years, when there is a new Attorney General, must he be bound by that? And that raised an issue with how Parliament created the Office of the Special Prosecutor.
In fact, that question I was asking on another chat with some other colleagues before coming on air. The question as to whether or not any AG could enter a nolli proxicui for the OSP. Exactly. Could that ever happen?
Exactly. And today, that is a very problematic thing the AG would do. And it will not sit well with... You see, we have to look at the public reaction to the AG do that, to tell us the intention of creating the Office of the Special Prosecutor.
But if the Act mandates him that you're acting on the orders of the Attorney General, he could simply do that, isn't it?
See, the Act does not specifically say that. That's why I said the Act tries to address that issue skillfully, so that you have given the person the power to prosecute without your oversight. That is basically what the Act is trying to do. And I find that very problematic, because whatever the OSP is doing it at the behest of the Attorney General. That is what the Constitution actually would understand in the nature in which the Constitution is framed. Right. So back to that crucial question that I asked. So in my view, for even if we are going to use an act of parliament to create the OSP, there should have been a sunset provision that says that at the end of an AG's tenure, the subsequent AG or the new AG coming in should determine whether he can do so, maybe by filing a new fiat at Parliament.
Was that not addressed by the tenure system we've given to these SP?
No, the SP has 7 years, right? And that clearly overlaps with the 4 years, right?
Of a president.
Of a president. I mean, we are not very certain that a president, for example, during Mohammed's second term, Mohammed's time in office, this next 4 years, it's not going to, he cannot run for another term, basically. So it ends, No, he can't, actually. The Constitution does not allow him. So it ends after the 4 years.
I know, I'm just yeah,
right.
No,
so when it ends...
Yeah. No, guys, calm down. I'm not saying he will run. I'm just asking questions. It's just my job to ask questions, please. It's a harmless question. Please, calm down.
So when it ends in the next 4 years, whether it's an NDC government or it's an NPP government, there's going to be a new president.
Yeah.
And that president will appoint another AG. Whether it's the same AG, if it's an NDC government, that AG will be beginning a fresh term and may decide to appoint someone else to prosecute on his behalf and may not have any use for the office of the special prosecutor. But we have created this permanent institution, and I get people make the argument, well, the AG can withdraw his. Then what happens to that edifice we have built, that institution we have built with this history and convention that have been established and we have funded for this period? So it clearly tells you that the understanding of Parliament in creating the office of the special prosecutor was not to create a transient office, a temporary office, but to create an enduring institution that even goes beyond Attorney General.
Have you thought of the impact or the effect of what you're doing in courts? The fact that technically it could render this whole office, I don't want to use the word, non-functional, but then it will now be at the behest of the AG. Technically, the independence will be gone of the OSP.
Yeah, so that's why I said, for instance, and I think a lot of people have not looked at this. Yeah. That's why I've always said that I began this conversation somewhere in 2016, right? But I didn't file that case till now. Because I knew people would say, what we are trying to cure, you are trying to destroy it, right? But that is not the reason, right? Let's take South Africa and Kenya, for example. South Africa and Kenya face the same situation we face. And what South Africa and Kenya did was, through their new constitution, so Kenya, for instance, created the Director of Public Prosecution to prosecute all criminal offenses. So the AG has no role in any of this. My position is not that the Office of the Special Prosecutor is irrelevant. No. My position is that we have to constitute it properly by amending Article 88 to create the office within the Constitution.
That's an entrenched clause.
Yeah, we can amend. We are going to an amendment process today. Right, so the committee amend the Constitution can amend Article 88 or can propose amendment for Article 88 and then provide for the Office of the Special Prosecutor or any other body.
We want it to be provided for.
Exactly, within the Constitution. And that is where we resolve all of these issues about the OSP. And I have to be very, very candid about this. Look, the NDC is not the only party that has issues with the Office of the Special Prosecutor. Right. The NPP, even in recent times, have raised legitimate concerns about the validity of the Office of the Special Prosecutor. And our current Attorney General, when he was in Parliament during the time discussions were ongoing to create the office, that's Dr. Ayine, raised issues about the constitutionality of the office. Bipartisan, both the NDC and the NPP believe that there is some constitutional issue that needs redress. Right. If the issue is not addressed today, it will hang over the OSP for as long as the OSP will be prosecuting in this country.
So this is not directed at this OSP?
No. It's not. I have no issue with the office specifically. My interest is the Constitution.
And what the Constitution says.
Exactly.
Awal, you have wanted to come in.
Yes, so please, let me just lay this background before I go into it and you understand it, not interject me.
No, I won't.
In October, the Attorney General wrote to OSP to give them the documents of the extradition of Ken Ofori-Atta. And the OSP responded that it will take time and he will not submit that document. The Deputy Attorney General, Justice Sai, speaking to GH1, said that we have made several requests to OSP, written letters, written demands, asking him that you've announced to the world that you are ready to have this person extradited. We did not have the document from OSP. That discussion started. Then the OSP also came back to say that indeed he was not submitting the document and so on. Now, just within 2 months, someone from the private office of the Deputy Attorney General is challenging that office, constitutionality of that office. Is it not really surprising that someone from the private office of the Deputy Attorney General who was seeking a document from OSP.
Who is that? Who is that someone?
Justice Sai. He works at the private office of.
Are you very sure about that?
Yes.
Would you want him to clarify that? Then I give you the chance to move so that he.
So you don't work there?
No. So let him clarify.
Can I clarify?
Yes.
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 Okay.
Right.
So
that question is. I've
seen that. I wasn't expecting that from someone like Awal do.
So let's allow him to explain.
Since Awal wants to do politics, or then rope me into politics, let me just address it. Two things. It actually speaks to the independent thought of Awal. One, that Awal is saying wherever he has worked, he can be used to do the hatchet job of the person he has worked with. And I find that, but basically that's what you are implying. That because I have worked with the former deputy AG, it means whatever I'm doing will be at the instruction of the deputy AG. And that speaks to your integrity. But let me move beyond that. I don't work in the office, the private office of the deputy AG. I have worked there before.
Okay, that's
right. No. Let me clarify.
I'm still telling. I'm still saying something that he will still have to respond.
But just hold on. I'll give you the time.
Okay.
Let him clarify. Okay. I'll give you the time.
So I've seen that on social media a number of times, right? And I've heard comments
so
from
when it's done, then we'll ask him the question.
Yes.
So please let's.
So I operate my own private law firm, which is called NT Ephraim Law in Abelempe in Accra.
Okay,
and I've been operating that law firm since 2022 when I finished with my master's in the US and then came back. So it means that even in 2021, I wasn't even in Ghana. I was doing my master's. I didn't work in the AG's office, the deputy AG's private office at that time. I did my pupillage with him.
Legal team over there.
Yes, of course, and a lot of people
just
do that.
Judges in the
so that's one.
Just
Two is that
in the Supreme
his
Court
initial comment right now. His initial comment right now. He said he wanted the thing to go without public notice. You said it.
Yes.
But unfortunately, it came to the media, and we're now discussing it. The first person to break that news was the Deputy Attorney General on his Facebook page. You see the synergy of what I... the first person is the
why is that a concern?
And it was a night.
Why is that a concern?
It is a concern because you're doing the hatchet job for him.
See?
But that's
clearly, you're doing it for him. Because you see, the thing is that the man has issues with the OSP. That's one. Two is that someone who cut his teeth in his private office has gone to court. And the person sits on this platform right now and say that, well, I didn't want the thing to even come public until the case is being determined in court. Then the first person to break the news, not the media, is the Deputy Attorney General, his own boss, who did that.
Can I give you an example?
Did he want it to be in public?
Let me give you an example. You recall when the anti-LGBT issue was going to court, Richard Sky, one of our colleagues in the media, was not even, I don't think he was in court at the time. He was almost going to court.
Yes.
But the president, at the night with the diplomats, went out to say there's even a case in court. So he said it hours before even Richard Sky.
Yeah,
so he's going to court.
Richard Sky published it on his Facebook page that he will go to court.
So if he's gone to court and the deputy AG knows about it, he can't.
It is possible. It is possible that the Richard Sky president have seen it and has sought.
So if
you understand,
so the deputy AG also sees his case in court. He can't speak about it.
There's nothing wrong with him publishing and everything. Yeah. My issue is that because he said he didn't want it to come out, and the first person to break it was the deputy AG who had issues with that is one. Two is that what is the difference between his case and that of what was determined by the Supreme Court on the 11th of December 2024, that in the case of Ken Kranche going to court on the same issues. I don't know the difference between his case and that, because if that is what he's seeking, then it means it has been dealt with unanimously by 9-0. But let me come to really the Office of the Special Prosecutor. There is nowhere that says that the Office of the Special Prosecutor is independent. When you read the OSP Act, and the clause 2, section 4 of the OSP Act, is saying that it suggests that the OSP is not entirely independent. You understand? And they are under the purview of the Attorney General.
But if you read that same act, because that's where concerns are coming up from, there's a portion which talks about the fact that the person, the SP, cannot be subject to the control of any other authority or person. Have you read that?
Yes, cannot be subject to any control, but it has a board. And it's a board that authorizes all prosecution.
Provided for in the act. The board
they are under the purview of the Attorney General.
The board does not enforce operational matters of the OSP. It's provided for in the act.
The board will have to authorize before he can even go to court.
No, Awal. I mean, I've read the act too. I mean,
myself, I've read it.
Yes,
so
but
what does the board
how
do?
are you reading it?
So what does the board do?
The board doesn't control operational matters. In fact,
no, I didn't say that the board will have to do all the day-to-day administration. It doesn't happen anywhere.
Yeah, but
in corporate governance, even in corporate governance, the board of an entity doesn't really dictate the day-to-day administration, but they give policy direction.
Yeah, but not prosecutorial issues.
You see, but what are they there to do? The entire office is there to do investigation and do prosecution. You understand? And the board, my point is that the office of special prosecutor must stay. The officer there is incompetent and must be removed. That's my point. The office must stay because even the president, in his address to the clergy, he said that is the only office that has prosecutorial powers. And if you have to take that office off, it means you're fighting the office that is designated to fight corruption.
In which part of his or portion of his reliefs, or I mean, the issues he sent to court, asking for the dissolution of OSP? He's not asked for that.
You see, the challenge has...
Have you read it?
No, I'm saying that.
Have you read it?
I'm coming. Yes, but I read a portion of it. Yeah. I'm saying that I am not speaking only his rate. I am speaking to 2 or 3 things. One is that the leader of government business and Dafiamapo have drafted...
Guys, okay.
They've already drafted
Let's listen to
a legislation, a private member's bill challenging the office, which the president had asked them to withdraw, which is also problematic because the checks and balances is not working again. It's problematic for him to even ask them to withdraw. And we're thinking that, well, it will be through the back door for you to tell them withdraw. But the moment you tell them to withdraw, you are almost trying to control parliament. That's the reason when I come here, I tell you the president is turning himself into a supreme leader.
So
controlling almost every state institution. And he wants to control parliament.
You have not provided me with evidence to prove that there's something...
What the president did by telling the majority leader to withdraw the case, he is trying to control parliament. Yes, because you see, Parliament has their distinct function.
That's why he's going to court, just to ask for clarity on the independent aspect. Yes.
The court that is going, I think that the office of whatever be the case, whatever relief he is seeking, what I want to know and what I want to even establish here is that the office of the special prosecutor must stay because we have invested heavily. Look at last year. We spent over 100 million on capex alone. So if we have set up this office and the president is saying that it is the only anti-corruption office over there, the most important thing is that the officer there, Kisia Jabi, is incompetent and is not fit to be in that office. However, the office must stay and work and fight corruption. That's what I want. That's all.
You have any quick one so I can give counsel also that thing?
No, so I think I don't want to talk politics about this because it's irrelevant. But one of the things I think I expect better from people like Awal is to understand facts before they respond. Clearly, Awal hasn't read my rate, and he has been just sent like what he's implying I have done.
But have you seen those comments online though?
No, I've seen
lots of people asking the rationale. Are you doing this together with government? I mean, is there a plan? I'm sure you've seen some of the write-ups. A lot of people.
No, and that
some people have brought up some pictures that you worked just as he's asking. I'm sure you've seen all of that.
Oh yeah, and I don't. Semsa is a very important person in my legal journey.
Right.
So there is no way I am going to dissociate myself from Semsa.
Right.
The point is that there are judges who have worked in the Akufo-Addo's chambers who are judges today.
In the Supreme.
Are they there doing Akufo-Addo's hatchet job? Anybody who thinks that way, I think, is not really doing justice to the brains that has been given to the person. I believe if you are thinking clearly as an independent person, you know that after some time, you should be able to think on your own. And when I work with Stremsai, for instance, that's one of the things he always pushed us to do, to have independent thoughts. And let me say this. when I sent my case, which was a week before Stremsai posted, right? Justice posted because that was the day he was served. And this is not the first time he has posted about any case that has come to him. He posted when Shafiq's case was served on him. He posted about the fact that the Wesley Girls case had been filed, and then he would be going to court to respond. And actually, a week before that, he was in the news. Stremsai was on his Facebook page talking about the fact that his genius, that is those of us who have worked with him before, because the person doing Shafiq's case also worked in Justice Stremsai's chambers and had sued him. So he was saying that, oh, now his genius have even now brought cases against him, right? So it's to tell you that as someone who works for the office, which is a state office, using his platform to inform Ghanaians that a case has been brought against the state, will have nothing to do with me. Because if I wanted the case out, which I have said, as a lawyer, I would have posted that I have sued this particular person. One of the things the NPP guys do not know is this. In June this year, somewhere in May, when Chairman Wontumi was arrested, no NPP lawyer filed any case in the Supreme Court challenging what was done to Chairman Wontumi. I filed a case challenging the arrest and detention of Chairman Wontumi without he being presented before the court in 48 hours.
Oh, you did that?
Yeah, I did that. The case is still in court, and it was against Justice Stremsai, who is the AG. And it was Ioku which arrested the person so that Justice Stremsai's office will bring the person before a court. No NPP person.
And Stremsai didn't also publish it.
He wrote about, that's why I said he wrote about it. He wrote about it that his former protege is the person who is challenging the bail cases before the court. He knows the name Chairman Wontumi, so maybe that's why you did not see it. But if you were following issues, you would have sent that.
No, I follow.
There were NPP people who reached out to me and said that, well, that's a very bold move by you. Nobody questioned the fact that I had a relationship with Justice Stremsai at that time. I am someone that, as I said, I believe with my integrity. And when there is an issue that bothers about the Constitution, I don't need a nod from anybody to file the suit. I will file the suit concerning that. And let me come to the Ken Kranchi issue briefly. I find it very problematic when people say it is the same case. If you've read the cases, they are absolutely different. And even with the Ken Kranchi case, the Supreme Court never gave a final judgment on the case. There were technical issues where he filed the case. In 14 days, he did not file his writ and was later seeking a process to file he didn't file his statement of case.
Yes, so what's the difference?
So the court never gave a judgment on that case. Okay. The court never did. My case, I'm hoping a full judgment of the court will be given, right? And one of the issues that I have raised, and I said it's a very interesting issue, for instance, was never raised in Ken Kranchi's case. I am saying that a sitting AG who even decides to appoint someone cannot bind subsequent attorney generals to it by reason of how our constitution is formed or framed, right? So it is something that has to be cured. So that if we want an independent body that would work the way we want that independent body to work, that issue of constitutionality will not be hanging over the head of that person.
Councillor, let me hear from you also on the whole, legal.
Well, so I think kudos to my senior and friend. I want to celebrate him for bringing this application before the Supreme Court. Under Article 2 of our Constitution, then Article 130, a Ghanaian can bring an action to court seeking for interpretation and declaration. Right. Exactly. So, I mean, what he has explained extensively, saying that it is a procedure for the establishment of the office that he is challenging. He wants the Supreme Court to bring finality to that particular matter. He doesn't have a problem with an office of a special prosecutor. He said it several times here. And I think that I can associate with that position. It's also important to note that the office of the special prosecutor has served us in many ways and continues to serve us. It's a very important office. It was brought up in the exigencies of the time just before the election, I think 2016, thereabouts. Then candidate Akufo-Addo promised that he was going to establish an independent office to deal with corruption cases. At the time, the procedure for setting up the office was not properly interrogated. I mean, a lot of questions were asked and it
even went to Supreme Court. You remember challenging current Attorney General went to Supreme Court challenging the eligibility of.
Allow him. Because that's a different issue.
Just let him land. I'll give you the.
That's a different issue. That's why you have to allow him.
So I'm trying to say that in the lead up to the elections, we had a lot of opinions and people wanted to know how that office was going to function.
Yes.
Vis-a-vis the provision in Article 88. And you see it has gone full circle and has come back to onto the front burner. So I'm saying basically that if this action before the Supreme Court is going to bring some finality, to the issues, and then also maybe the Supreme Court will order. And I remember that at the time there was also another opinion as to rather waiting to amend the constitution before establishing. He said that he was in a hurry.
Yeah.
He didn't have time. He had made promises to Ghanaians. He wanted to start something immediately. And in the course of time, depending on how the office functions, we can amend or vary. And I think that we will need an office of the special prosecutor. The other discussion is whether we should decouple the Minister of
Justice.
Exactly, from the Attorney General's office. So these are related matters, and I'm happy they have come to the front burner. As a student of the Constitution myself, I want to encourage my brother
to go ahead
and accept that I wish and I pray, whatever the outcome is, we should take necessary steps to cure whatever procedural and constitutional issues there is, so that when we have an office of the special prosecutor, he's properly independent of the office of the Attorney General.
Yeah.
So I think this is a win-win situation for everybody.
For everyone. Yeah.
Nobody. I have not heard anybody on this table saying that.
Enti abusiafo ensem no na yakwakuti aba no na enne ye da ye papa ye Charles Kojofusu enyuntofo he dabi onu nyuntofo he enyuntofo he ye ura ye bonidin Nana Kwame Ampadu watiase ye promo na mo ye nyuntofo he na Nana Kwame Ampadu kan but yewra na Charles Kojofusu ntwiso legend watiase onu so wabeye bi papa yintimi nka without say yebe man sa respect no nti na chese eno nso eno no na enti abusia ayasem enti madika ka kire mo NPP die si party na gwawi obi obeka si party ni nguyi bia no na wonim di okeka obi obeka si NPP party na nguyi bia no na wonim di okeka because we ensema omunko fortuna TV so omutena radio so omutena social media eka nsem bibiri and sometimes among who say party no am say panyin bi ani party ni mo and ema odwin say party na nkasa kra no empanfo omu share party na se empanfo a omu de omu kra bo afode adima party no omu ohefa. You begin to ask yourself that question. You get me? You begin to ask yourself that question because sometimes it makes very sad. Say biti se Canadian Japan or dini sika ura party ni mu pen. What me alternative so a support party no either good or bad. Na a name ura yo mu ye ni say. Na eno ura yi ono nso pese odi party n'anim eno mo mfa nchemi na ono nso omumpɛ sɛ obedi party n'anim no deɛ odwen ho awonte ase. And I've always been saying this, says NPP dwen sɛ omo de Bawumia bɛba ama Ghana for ato aba mo a, they should just forget it. Because Alhaji Dr. Mohammed Bawumia ebe contest 10 Ghana for better about any 10. I fear Ghana for air quality for real run regions, you know. Abusha for a yasem. O dear mamin for we see mess also do comment beto a comment session now I like it you didn't wash share now for any be at any be actually what you say any be beat me a coso. It's say pressure be amount to machi what I saw voice now. Medi me offer sim eko baby nti o say metimi ye quick na menu omo eko eba na yekoba wacha say yebetimi edi nkomo kama on any other matter ebeba wacha say na yeto aso conversation wo ho kama bibi etimi akoso wano ntiabusafo until then dear mamemfa wunsi na meso so be hwe ho so yi especially ukodadi lumba yi nbia hwe ho ye because Ghana dear any single aibiano omo de faso eye niema nti mesro so obekọ ho no bia na wahwe omo yi se obeya nkonya asem na ye papa Charles Kwadwofusu yakopon fa currency yi baba ye no obehia o heaven what you say ade na wo sere behia o heaven sa na ade no akwakoye nti it is sad ya tede dilumba onyomo aye no wonachi nyina oh imagine senka we nyina nsi anka yi oh wo kan say na yi enye hwe bye bye.